Um, and thank you, audience, for turning up. We are going to actually be opening up the session to questions once we've discussed what we think are the fundamentals of the contract. I know most of us are here, or a lot of us are here from the publishing world already, so I think the question is going to be, why are we looking at something as basic or as we take for granted as contracts? And I think the answer is exactly that. I remember I was chatting with Amrita and we were saying, about contracts. Is there something that you particularly want to talk about? And Amrita said, interestingly, that, actually it's interesting. I don't really go into the nuances or the nitty-gritty of it, and I think that's what a lot of us do. We take a few things in the contract for granted, and it's always a good time, and especially now, where the world of content creation and consumption is changing, both organically and also because of changes in technology. Of course, we are going to discuss AI, we are going to discuss platforms, and we are going to discuss, like I said, a few basics. Our panel today is a very accomplished one. Amrita wears several hats. She's a published author and also has vast experience across multiple platforms. Former journalist, runs a very successful podcast, and runs an online health collective. And I think she is in a very particularly good place to tell us about how she views content and contracts. Dhruv Singh runs a very successful practice in Delhi and has done extensive work on copyright with publishers like Penguin Random House and technology companies like TikTok. Personally, he's someone I have worked with and admire greatly, both for his knowledge on everything legal, but also for his wisdom and his ability to see the larger picture with clarity. And with that, I'm actually going to open this up to Amrita first. What does a contract mean to you?
Well, since I'm sitting next to Dhruv, I defer to legal counsel. But I would say, what I was telling Hemali, and firstly, it's really lovely to see so many of you here. And when we do open for questions, I really suggest you direct most of them towards Dhruv. And I would be happy to listen and make notes as well. Not to stress you out too much and put you on the spot. But I was telling Hemali, so I have now 3 novels and 4 works of nonfiction, which I co-authored with leading mental health experts under my belt. When I started out in 2010, and my first contract came to me from a publisher, and I got commissioned for my first novel, I had no idea what I was reading. I was just so excited to be signed up. I had no idea what rights I gave. They were world rights, which I gave. I was looking at the sort of advance that I was going to be given, negotiating on that. And that's still something I see with many debut writers today. I've been canvassing a few folks at the festival to say, what is it that how do you look at contracts? What do you think? And I think at this stage, Hemali, I feel like because things have changed so quickly in the content landscape, I don't think any writer likes this conflation of writing and content, but it is now a sort of content creator ecosystem that we have to be across. We all have to get a lot sharper about those clauses. So now I read the contracts pretty carefully. I often say, though, I suggest people do defer to legal, like a friend who's a lawyer, because there are certainly always clauses you can't really pass yourself. Yeah. Or an agent, because you're looking for people who have expertise in this space. It's easy, I think, for many of us to run things by ChatGPT, as someone told me they just did, and then negotiate at a higher a sort of percentage. But it's for me, I think that the big change for me has been to break that narrative in my own head that, hey, I'm a writer, I don't get it. To say, educate yourself better, ask a friend who's a lawyer, ask an agent to help you pass that contract, because it really is something you're signing, and you need to be aware of what you're signing.
No, and you're absolutely right. Even at a suitable agency, a lot of the conversations we have with writers, and especially debut ones, are about contracts and clauses. But interestingly, now with the evolving landscape, a lot with writers who have been published before. Like, for instance, and we're going to discuss some of those. We're going to discuss AI, we're going to discuss some of those clauses. Formats. I think people want to have those conversations. They want to know more. And this is where, Dhruv, you come in.
I mean, I'm very glad you said what you said, because it means more work for people like me and the ability to make more money. But, to start with, there are 3 points that I'd sort of like to start off on, right? The very first is, like Amrita said, if you're not fluent in legalese, you absolutely do need an attorney. And, there are a lot of us. There are a lot of really good law schools, and you throw a stone and you hit a good attorney these days. So there's absolutely no reason not to go to an attorney. If you think that there isn't adequate revenue to appoint one specifically for your matter, then as Amrita said, ask a friend that is a lawyer, or some relative of yours, maybe your second cousin removed is a lawyer, or the neighbor's kid has just passed out of law school, right? You ask for that favor rather than having terms come back to bite you just because you're too embarrassed to sort of negotiate or ask somebody for help. The next point that I'd sort of like to raise, and this is something that I've seen happening quite a bit, is authors are often too embarrassed to ask questions about contracts themselves, right? They don't want to be seen as perhaps difficult, but wherever there is a difference in interpretation on language, or there is some room for doubt, you absolutely need to go back to your publisher and ask them what they intend with language that is within an agreement, right? I've never seen anybody lose out on a contract purely because they ask questions and clarifications and seek clarifications. And thirdly, as with any agreement, parties have different levels of leverage, right? So when you're starting off, it's perhaps your first book, you don't expect a lot of revenue to come in as a result. It doesn't mean that you let the rest of the contract be, right? There are obligations within the contract that flow from you as well. There are liabilities, there are indemnities, there are representations, which should all ideally be looked at by a lawyer. And it's extremely important, particularly if you're starting out, it's your first work, you're not fluent in legalese, that you do ask for help.
Thanks, Dhruv. What I am going to do is also ask you some of the questions that we get asked on a regular basis, because I think that might also help clarify a few things. What does copyright mean?
So, for dummies like me, copyright is essentially just the ability to replicate work, right? It's the reward that the law gives you for the sweat of your brow. So it is the exclusive right to reproduce a work, which the author can then give away to a publisher either by way of a assignment or a license, and it's usually entered into by way of a written contract, as a result of which there are obligations that come in from the publisher as well. These include royalties, of course. They also include other obligations, such as sticking to the territories and the formats that are written into the agreement, providing you a regular run of the accounts. Every contract takes on a life of its own, and it needs to be looked at individually.
Right. One of the questions that we, again, get asked very regularly is, do authors need to, and especially this is from debut authors, do they need to register their work with a body before submitting it to publishers? How do you actually protect your work?
So that's a good question. You don't actually need to register a copyright in order for it to be protectable, right? As soon as you write a piece of work, it becomes automatically protected under the law. You can register a copyright. The only difference being that when you have a work that isn't registered, when you sue somebody for infringement, say, you then need to go to court to first prove that this work originates from you. You need to sort of satisfy that prima facie level that the work does indeed originate from you.
Right. Do you want to, a contract is a vast thing. So do you want to maybe tell authors or writers the top 4 or 5 things that they should be looking at before signing a contract or before considering a contract?
Sure. I'll leave royalties out because they are obviously a matter of negotiation. Term, which is the length of time that you give away rights to the publisher for.
Yeah, and we'll discuss each of these.
Yes, right. Then there are territories. What's the point of giving away territories that the publisher doesn't have a presence in, right? You might want to be able to enter into that agreement with another publisher and perhaps be able to get revenue for it. Format, of course, if you give away rights in print format, you shouldn't automatically give away rights in every other format as well. You need to know what intention the publisher has with your works. usually ebook and print go together. But the publisher may or may not have plans for your audiobook, right? You might want to enter into an agreement for that separately, or else if the publisher wants it, you then provide them a right to be able to publish the audiobook within a particular period of time, and when they fail, that those rights revert back to you.
Yeah. Just for
When they
clarity,
fail.
yeah.
If they fail.
I think just for clarity, most publishers actually do kind of insist on print, and audio. But it's a good point in terms of how much time can you actually have rights lying with the publisher. And I suppose that's negotiations that you get into individually with the publisher. But yeah.
Can I add one thing here is that it's the first time I've actually met an author here who said that they held on to digital rights. So again, play to your strengths, and knowing that you can negotiate these clauses in the first place is such a strong position to come from. The other one I've heard a lot from, as you said, territories. Someone also said that the standard clause usually includes first right of refusal on the next book. When you're a debut author, you don't know you can actually push back on that and say,
That's very true. I've seen that happening quite a bit. And as far as dramatization rights are concerned, I've seen it go both ways as well. Yeah. If you're in a position where you think you'll be able to negotiate a particularly good deal for yourself, and you have the wherewithal in order to be able to go through that with the production house, then you'd absolutely not want to give those rights away to start with. But on the other hand, if you're just starting out, you don't know what this particular work will turn into. Yeah. You'd much rather have somebody else deal with it to start with.
You mentioned term. Should we talk a bit about what that really means, and what does term for a certain period versus full term mean?
So essentially, term is the length of time that you give to a publisher in order to be able to publish your work, reproduce it in return for returns like royalties. We've seen this happen increasingly, that there was a trend towards giving away the entire term of copyright, which is life of the author plus 60 years. But a work has a life, right? And you never know how it's going to turn out, say, after 5 or 7 years. Maybe you'll be in a better negotiating position and be able to get yourself more royalties if you were to negotiate another contract 5 to 7 years down the line. It doesn't make a lot of sense to give away rights for the entire term of copyright, and we've seen a trend away from that.
I did want to come to this later, but I think it's good to get into the AI and content generation conversation now, because so much of this is actually being reflected in the conversations that are happening. How does copyright and AI look like in the world of significant use of AI in content generation? Simply put, what should a writer be looking at in terms of any clauses, given the inclusion of AI?
Well, I'm going to sort of look at a slightly different aspect of this, if you don't mind, to start with. You're all likely aware of the ANI litigation that happened against OpenAI recently. OpenAI being the company that runs ChatGPT, right? That litigation happened because the large language model was apparently being taught on copyright-protected material, right? Now, the position as far as Indian law is concerned is not crystallized on this particular issue at all. So teaching text and data learning, which is what it's called, TDL, isn't necessarily a violation of copyright under Indian law. So essentially, like we spoke about what copyright is, which is the exclusive right to reproduce. If somebody else reproduces work without a license, reproduces your work without a license, that person should be in violation of your copyright and hence commit infringement. Unless it falls within a set of actions which are under Section 52 of the Copyright Act, right? Which are essentially for private use, for critiquing, and for the publication of news and current events. So one of the some of the arguments propounded in that particular matter were that, these were the very purposes that ChatGPT was intending to assimilate that copyright material for. So that's very much still an open question. And it's something that we don't have an answer to right now. There are a number of countries that actually have a text, data, and learning exception in their copyright law, which means that you can take on such copyright material and teach it to a large language model without offending the copyright of the author originally. Now, the second aspect that you were talking about is with regard to who owns the content.
Yes.
So look, the Indian law doesn't allow a machine or some software to own copyright in the material, right? So it's the person giving the prompts. That does leave questions open with regard to plagiarism, with regard to reproduction that the AI has done, but that's just one of those things that needs to be looked at on an individual basis, on a case-to-case basis. It's the amount of taking that the court will have to look at. It needs to be gone over with a fine-tooth comb in every single instance.
Amrita, do you have any questions around AI also given your other platforms? Like, is that something that you are seeing in terms of changing the very nature of agreements?
For me, when I'm looking at the storytelling platform, for example, the Health Collective, I think we have moved very quickly. I think editors, for example, when you're curating content, for us the challenge is just ensuring people are declaring use of Gen AI. Earlier we do a lot of checks for plagiarism. That was a norm, even for independent outfits. And now you have to have enough experience because the AI detector, the AI tools that detect AI are not very reliable, which has been widely reported upon globally as well. But I know in the news, media, and let's say long-form content space online, it's become a huge challenge because, of course, we're all using ChatGPT or Claude or whatever every day. And I think when it's not declared or attributed, you lose a lot of that, reader trust and credibility very quickly. And I think sometimes in these conversations, we forget that actually our audience is the reader. It's the layperson. It's the person who's coming. So even for an organization like us, which is pretty small, we have to be clear that we have an attribution policy, or we have to be clear that we have disclaimers. And when you have, and I'm sure for publishers and agents as well, this is going to be coming up more and more in contracts, that either you have a clause saying that you're not going to, that the author is saying, I declare that I'm not using Gen AI in my writing, that this is all my original language and original thinking, because it is getting more and more complicated.
Yeah.
That's interesting because the way I'd look at it, even if you have used generative AI, you've given the prompts, right? So I'd actually, if it were up to me, I'd argue that that content is original content from me.
Okay, that's interesting. So you would say that just publishing what ChatGPT gives you back, basis your prompts, you think might be original content from the writer?
It's certainly arguable.
It's arguable. But is it the creative? That's where I feel like between the law and the, I mean, I don't think that's a legally defensible. I mean, for me to say, actually, I don't want to use this right, I'm not sure that is a legal thing. I would want them to attribute, to say I've used ChatGPT, and then you take a call on the quality. So I'm talking from an editorial point of view, for example.
That's a risk mitigation exercise. Yeah.
But interestingly, taking from that, so for instance, if there is a certain part, and bear with me, the question isn't fully developed yet, but if there is a certain part which is AI generated, is it also the responsibility, or is it also something that the publisher has to declare in terms of the authorship of the work?
I mean, I'd argue.
Is there a percentage?
There is no legal percentage that has been arrived at least not in Indian law, and to the best of my knowledge, it's not been crystallized in most other jurisdictions as well.
Yeah. I mean, I think it's still a very, very evolving conversation around AI.
100%. But see, then I think there's the contract you have with your reader, not the legal contract you have with the publisher. The contract you have with the reader. So if you have people, and again, as you're both saying, it's evolving as we speak. I'd love to know, in the Q&As what people think, especially aspiring authors. That gimmicky novel of like, oh, I wrote this book with AI, that phase is kind of over now. This kind of understanding that when a reader is picking up a book I say I've written, if I'm not including that the fact that actually
Yeah.
ChatGPT helped me with the research, or I put these amazing prompts, I'm sure they would have been amazing. I feel like if you're not declaring that as a writer, I feel like I'm misleading the
No, I
reader.
agree. I think it's
a
more a moral.
It's potentially a morally unjustifiable thing in your mind.
In my
right?
mind. But as one, I had a participant in a panel, which I love. This is my favorite story of the last few weeks, who said, had a question on social media and then said, all of the panelists, you all were born in the 1900s, so you don't understand things that are happening today. So this could be an old school way of looking at things.
Fair enough. We're going to come back to the question of AI, and I'm sure that we'll have questions from the audience as well. But I very quickly wanted to jump to some other things that we get questions around, for instance. Warranties and indemnities, which sounds legal enough. Do you want to maybe just talk the audience through what this actually means?
So I'll talk about representations. A warranty is essentially a continuing representation. A representation, essentially, you as an author make a number of representations in any publishing contract, right? So to the effect that all of the content that you've published is legal in every sense. It is not defamatory, it is not seditious, it doesn't violate the copyright of another person, it doesn't violate the rights of privacy of another individual, etc. This is another aspect that I'd urge authors to have their lawyers take a look at, because there is a lot of language that goes into these agreements. Like, for example, there's use of terminology like, the content shouldn't be blasphemous or otherwise improper, right? Those are not legal definitions. You can't ask an author to make a representation of that nature. It's the kind of thing that I would push back on. So that's certainly something to perhaps consider. So, all of these representations need to go into the agreement. Your representations can only be on the basis of your knowledge, right? To the best of your knowledge. And with regard to indemnities, an indemnity is a legal construct where if I've suffered a loss because of your actions, you are then duty bound to put me in the same position if I hadn't suffered that loss because of your actions, right? Usually, indemnity language in publishing agreements is written in, is provided in the event of, gross negligence and, of course, a misrepresentation.
That does bring me to something that I know a lot of people quiver at the thought of, but it does happen, and perhaps it's necessary to happen, legal reads. I think a lot of times you hear from writers who are fairly anguished about the fact that there are sometimes there are differences in what a writer thinks can be said and what a publisher thinks is legally defensible. So do you really want to talk us through that, how it happens? Because you've also worked with a publishing house, so you can give both sides of the picture here.
So essentially, you have those representations within every agreement already, that the content that you're going to have published is above the law, right? It meets all of the requirements in the law. The agreement also usually says that the publisher has the right to be able to have the book read by a legal expert. Very often these agreements also say that the cost of these legal reads is to be split between the author and the publisher. In effect, that's rare. It's usually the publisher only that ends up sort of paying them. And the reason for that is that the publisher also wants to have complete control over who reads the book, who carries out the legal read. So in a sense, the book is being vetted, right? And constructively, at least, if the book's gone through a legal read and been approved and then published, there is at least a subtle nod to the fact that the work is all right.
At what point do you think a writer should have representation in the question of legal read? Is that necessary at all?
I mean, right from the beginning, including at the time that the agreement's drafted, because your representations and warranties have a direct impact on how this is going to flow.
I did also want to ask you, Dhruv, about, and Amrita, you as well, because I think you have collaborated with others. So in the event of a book having more than one author, and I will probably give an example of, say, a translation. If the original work is being challenged, does it mean that the person who has translated it, but has translated it ad verbatim, are they also liable, or is the liability with just the original writer? But the question really is, in the case of a translated book, what is the translator's responsibility, and how liable are they if there is a
That's
problem?
a tricky question, Hemali. So, if I understand correctly, you're saying that the original work itself had questions with regard to infringement.
No. So what I'm saying is that the questions have come up because of the translation, because someone has read the translation, but the translation is actually an exact sort of translation of the original work.
I mean, then there can't be substantial taking of another work, right? Because that's what you need in order for there to be copyright infringement.
No, I'm not talking about infringement.
If there's like a legal, someone puts an FIR because this was a blasphemous translation, is
Yes.
the translator liable and the translator's publisher liable? If
Or
the
is it
original
just
one
the yeah.
was, if it was, I guess, exact translation of the original.
If it's an exact translation of the original, I mean, forgive me, I can't see a problem coming up only with the translation, not the original work, because if the original work is blasphemous, so will the translation be.
But they might not have noticed with the
They
original
wouldn't
work.
have noticed. No? I think
Right.
sometimes what translations, no, not sometimes, often what translations do is find new audiences. And sometimes with the new audiences, there are these questions that crop up. So, but
I mean, that's really an interesting question, and it's perhaps one that I'll have to look into. I mean, off the top of my head, I think that yes, I mean, whoever's carried out the translation, arguably, since it is a work of copyright,
Yeah.
the translation unto itself could potentially be sort of brought into a suit of that nature.
Right. So we're exactly 30 minutes in, and we would like to open this up for questions to the audience, if that's okay.
Yeah, I just want to add, before the questions, I just want to ask if you can have a show of hands of who's an author or aspiring author. Okay, that's great.
Wow,
Okay.
okay.
So one thing I would say is when I've been talking to folks today versus 10 years or 15 years ago when I started writing is that this framing has also changed, right? Now we are content creators. Increasingly you're hearing we are solopreneurs. So a lot of the way you look at not just your contracts, but the way you're writing, your brand, I think it's all changed. So it's going to be interesting to see what the questions are versus say even if we were doing this chat a few years ago.
Yeah.
Mostly ask Dhruv questions.
Well, he's the only one who's going to be able to take the answers on the legal front, but we are here to answer anything else. Should we start with you in the second row?
Thank you so much for this session. It's been quite meaningful to, I think, most of us here. As someone who has signed 2 book deals this year, I wish I could have attended it before. This had happened before. But still, with stubborn optimism, I am trusting my publishers, and they are big names, so of course. My question is, again related to this, as a debut author, how can we negotiate fairly when the power dynamics become uneven, as I felt with my publishers a little bit?
So I just want to jump in here before Dhruv answers this. Publishers are not usually out to cheat you. I
No,
think
they are
this is
not.
not the point of this. No, I just, not because of your question, I just wanted to say that there has to be a reasonable and equitable balance in terms of how both parties approach the agreement. And so the idea really is to demystify and not go down the publishing rabbit hole. But that said, Dhruv, do you want to take that?
I mean, I'm sorry if this answer is very dissatisfactory, right? But in essence, if there are 2 parties and one of them has all of the heft, you're not going to walk out with a lot of rights or a lot of royalty out of that agreement.
Get an agent.
Oh, yeah. Can I also say, I think that, we were saying at the beginning, have a lawyer look at your contract, have an agent look at your, get an agent, have an agent look at your contract. Writers themselves will talk to each other and, sometimes say this is something that you might want to know. But also, like Hemali said, of course, it's not meant to be a fractious, combative relationship from the beginning. And if that's the case, and not in your case specifically, but for anyone else, I think that's a sign that this is not going to, maybe not a great sign for your impending relationships. I've never met people, even when they're negotiating contracts, who will not understand why you're pushing back on something if you make your argument. But I think, again, it comes back to the point that no one has had these conversations. So it's great that, Jaipur BookMark is hosting this. Push back where you feel that there's something you need to push back on, I would say, and then see what legal has to say.
Yeah.
Maybe I should ask a question, but I'm going to, don't spend too much time on it and say we can talk later. I'm going to go back to that last question. The original in Marathi, the author is deceased. The new translation that was published this year, the copyright of the translation will rest with the translator because the publisher has the opportunity to get the book translated by anybody else all over again. But because it's come to light that the original was offending somebody's sensibility, I'm going back to the culpability of the translator because there's a lot of translation being published. It'll be important, I know it's complex, but it'll be important at least if you unpack to say, where does the liability lie? Where does the copyright for the translation lie? And what's the publisher's position in a matter like this?
The copyright for the translation lies with the translator. Now, it is a creation by the translator. The translator would argue that he's been commissioned for that particular translation and it was intended to be a literal translation. These are arguments that I'd make before court, right? To state that I am not responsible for this literal translation in the sense that it offends somebody purely because it is an act of translation, right? Having said that, truthfully, I don't think that argument will always fly before a court. Because it's naughty in the sense that you are proceeding to publish the same content. So you can't on the one hand be enriched by the translation and absolve yourself entirely of the liability.
Yeah, so the responsibility for allowing that offending content to be published will rest with the current edition.
Correct. I mean, off the top of my head, that's certainly what I think.
Fair enough.
I feel like this is a specific case.
Yeah, this is that rabbit hole I was talking about because I don't think, no, you're right, because again, I don't think that people are going to necessarily do a legal read on a translated work. And yeah, okay. So then it does lie with the translator, right?
I would like to think so, but I could stand corrected.
Okay. Yes, sir. Can you wait for the mic, please?
It's really wonderful session going on, and myself, SS Dogra from Delhi. I'm journalist author. My curiosity is there any contract for translator also? Because
yes, there absolutely is.
Because I have never heard about it, because she was finding all these things, and translator also plays very important role. Then is there any contract?
They should absolutely have a contract.
Yeah, they have a contract.
Okay.
Translators have their own contracts.
Okay, thank you.
I think we'll go row by row, so we'll come to you.
I think you depicted very well the emotions of a first-time writer. Mine is totally lost in a legal jungle, which I do not even know the name of. Right? At the age of 76, I published my first book. It was more in deference to a posthumous, it was done posthumously. My mother's wish was that I write a book, and I wrote a book. And I was very happy to get it out into the world. And there the matter rested. I was not worried about how many copies it sold or anything like that. Then I discovered that it was traveling all over the place. It had gone to North America, Latin America, Europe, Southeast Asia, Oceania. Now, whether that means something or not, I do not know, but certainly it's going all over the place. And I had taken a small package with a self-publisher, whose name I shall not mention here. Up to the point the book was printed, and then he started, they helped me go live, then it was a total silence. Till this day, I do not know what the sales are. I mean, it's been in so many countries, surely there must have been some sales. Nothing about royalties. I'm not really worried about the royalty. But if there's something which is due to me, I think it should come. And this was my, I think, a result. I'm culpable also. There was some legal things which looked okay to me, and I agreed to them, and also gave the publisher, right to, though I retained all rights to the book. So now, my name is Chandranil Dasgupta. If you just put it on today's Google, you'll see the book, The Wind in My Face. Yeah, as I said, it's only online. It's not in any brick and mortar store.
So sorry, I'm very sorry to interrupt you.
Yeah.
What is your question?
Yeah,
Because
the
we want to
question-
take as many questions as
Yeah,
possible.
the question is now, how does a new author, whose some context I've given, how does he protect himself to what kind of facilitation he can get? How can he get some kind of an armor before he ventures out into this kind of a world? And now the situation being what it is, what kind of redress can he get?
Great. I'm going to take a bunch of questions, so then we can go back to them.
Sure. I mean,
Okay, so that's one. So, yeah.
Uh,
Please
hi.
make your questions crisp. We want to take as many as possible.
Yeah, I'm Hitat, and I just wanted to know, as a writer, so what powers do the writer, the agent, and the publisher have to exercise when there are most of the legal infringements happens on two sides. Like either it's by the AI giant, which has millions of dollars in legal teams, and another who are roadside vendors who may be pirating the books, who are difficult to catch. So what rights can be exercised in both these scenarios to protect the rights of all three of these people?
So you mean around AI and around piracy?
Yes.
Right. Yeah. Questions here?
So out of curiosity, we had a conversation about AI being the writer. Where does a ghostwriter come into the play when a ghostwriter has maybe written something that is not acceptable or that is hurting someone? Who will be held liable for that?
the author.
So ghostwriter is, once the book is written, he's out of the picture.
You've commissioned a ghostwriter to do the writing on your behalf.
Okay, so the author is liable.
Very much so.
That said, the ghostwriter should also have an agreement with the author. Sorry, your question?
Hi, I'm Srishti, and I'm actually an independent editor. I work in freelance capacity with writers. Either they want to self-publish or they want to get some developmental editing right before they query an agent. So I also have a contract with my authors. My question is, so when they are working with an independent freelance person and they have a contract in place, what are few things that the author needs to keep in mind, and what are few things that I need to keep in mind as the freelance editor? This could also apply to book design, book cover designers and other people.
Thank you. Do you want to take this?
So, if I understand correctly, you're commissioning people to produce work on your behalf.
So let's say there's an author and I'm an editor for them, which means they want to send their work to me. I provide them feedback in the capacity of a developmental editor, which means I leave comments. Sometimes I give them suggestions on how to make their work best. Then they revise, I look at it again, and basically we co-create the work. I don't actually write for them. I don't change anything. I give them suggestions based on which they change their own work.
I see. So, it's a work made for hire situation, right? In which case, if you've been commissioned by the author, you sign over copyright for the content that you produce.
Basically, I'm just giving them suggestions.
Right. So you make edits, perhaps, right? It's questionable whether the edit itself has its own copyright in it or not, but because of the length of, is what will probably dictate whether it has its own copyright or not. But essentially, if you're being commissioned to create a work made for hire, you're usually signing over the copyright for that content.
Yeah. The question around AI and piracy.
So, we touched upon the AI bit a little bit, right, earlier with regard to ANI versus OpenAI. So if we're just talking about text and data learning to teach a large language model, it's still very much open for debate as to whether that will constitute copyright infringement or not. All right, at least as far as our law is concerned. As far as, physical sort of infringement and piracy is concerned, there are two options open to the author. It's either to take, steps by way of civil infringement suits or by way of, criminal infringement actions. Both have their advantages and disadvantages. Unfortunately, and this is a personal opinion, the sort of payouts for infringement actions, even when firstly, it takes forever to prove a matter in court, right? I've seen suits before the Delhi High Court that have actually carried on for a decade. And eventually, even if you manage to prove that there has been infringement, the infringer gets off with a slap on the wrist, right? Essentially, it's difficult even to get back the costs of the litigation. So we don't have treble damages and the sort that they have in the US, right? That does not happen. So what a lot of publishers do is that they take criminal action against pirates.
Was there another question that we didn't? Yeah, redressal against self-publishing.
I mean, for that, the agreement will be sacrosanct, right? It is what will dictate everything that all of your rights and duties inter se are going to be dictated entirely by the contract. I mean, the only thing I'd say is that the next time that you enter into a contract, unless you you're comfortable with the legalese.
The contract specifically stated that all the rights to the book will be vested in me. And the self-publisher would have no rights to the work.
And it is the publisher that is making sales overseas. I think you should.
Because I took a marketing package from them, and they helped my book go live, and they were placing the book to the online stores. But once that went on, that's perfectly okay.
I think you might need to get a lawyer because it's
Maybe we can continue this outside, but I just want to take one more question from that side because I feel like
it's already getting fragmented. May I just finish this, please?
We are really running out of time. Okay. One more question, but you can continue this. Dhruv is here.
I'll see you immediately
and
outside.
He'll have this conversation with you. Sorry, do you want to ask your question? Please make it quick. We literally have like 4 minutes.
Yeah, all right. So, for example, with Arundhati Roy's new book, right, the entire controversy around the book cover with the smoking. So, if, say, someone's not as famous as Arundhati Roy, right, and there is a controversy around a book cover, someone's like, whatever. So, how does legal, what are the issues? Like, how do you,
so the controversy was that she was smoking, and then that's the one, right?
There's a law that you can't show.
There's a law that you can't show that. It's a very good question, actually.
So if it's not someone as famous as Arundhati Roy, what are the challenges and who's liable in case there's another cover like that but someone who's not as well known as her?
I mean, it's immediately the publisher shouldn't have cleared that image on the cover. Publisher runs liability immediately as a result.
Yeah, okay.
One last question. Okay, there.
So I'm as an aspiring fiction writer, I was curious, given the current time, does web series come into your contracts? Does it figure in your contracts? Is it part of digital?
Okay, so this is an area that I was trying to actively avoid, right?
Because he did tell me not to go near that.
Yeah, because these contracts sort of take on a life of their own, right? And this is something that we were discussing immediately before our session, that authors very rarely have the stomach to be able to negotiate those contracts because there's just so much revenue that sort of comes in, and you don't want to push back when. Essentially, what happens is that you have dramatization rights that come through on contracts, right? They're a secondary right. You can choose either to give them to the publisher or not. I mean, it depends on negotiations, right? If you're well entrenched and well connected, you might want to take those rights to sort of sell yourself. Otherwise, if this is your first time that you're sort of dealing with it, it'll be much easier for you to actually go through the publisher.
I have a question for Hemali on that note. Do you have dramatization rights of Book of Dog? See, challenge accepted. When is the sequel? What's your moral obligation to not sign non-dog lovers at your agency?
We always try and get the dog into the picture and into the conversation, and we shall continue this outside. Thank you so much, everyone. This was very useful.
Thank you, Dhruv. I hope you have many new clients after this. Yeah.